any sort of estate planning, elder law, family property planning that you're looking at doing. Those initial consultations are complimentary, so it doesn't cost you anything to come in and talk to us. Usually we can give you a good recommendation by the end of that consultation of, what we would recommend, what it's going to cost, and give you the full picture. And we do schedule those for about 2 hours to try to give us plenty of time to go in depth and really give you a good recommendation. So if anything we talk about today or just general estate planning concerns make you want to come in and talk to one of us, please fill that out, and then we then have permission to reach out to you is what that means. Another thing that we're going to be sending to you is a handout on family legacy property and just a nice little chart on what that means and what we're talking about and ways that you can plan around it. If you're interested in these topics going forward, just a quick reminder that next week we're going to be talking about Medicaid spend down and what that looks like for people. So today we're talking about family cabin planning though, or legacy property planning. And there's usually a couple common concerns that people have regarding that property. One is sometimes long-term care expenses and how that might impact their ownership in that property. Sometimes it's just general asset protection for the next generation. Sometimes that's due to things like divorce or maybe liability concerns or bankruptcy, creditor type concerns, but still wanting to keep some people involved in the family, property, excuse me, even with those concerns. And I mentioned divorce and, is a huge concern for a lot of people, but also just in general, restricting ownership and who can actually be a part of this family property, whether that's due to divorce or due to a variety of other concerns. Restricting ownership is a very common key component of family legacy planning when it comes to these properties. So the first thing that I mentioned there is like concerns over long-term care expenses. And the reason going into assisted living or a skilled nursing facility can be a concern when it comes to these properties is because they're considered available assets in most cases if they're not owned by something like an irrevocable trust or it's not an operating active business of some kind. If it's not your primary residence, it's just a cabin that you use up north and you own a part of it or maybe even all of it. If you don't have prior protection planning done, it could be an available asset if you would need care. Now, that doesn't mean if you have enough to privately fund your care through income or other assets that you have to give it up or hand it over to the nursing home or anything like that. What it does mean, though, is that if you don't have enough to privately fund your care indefinitely, at some point, it could be something that if you were going to try to apply for a benefit through Medicaid to help pay for your care, they would say, well, that's an available asset. You're going to have to sell your interest in it before we provide care for you or payment for your care. So if keeping it in the family is a really big concern for you and not having it sold to fund care or to receive Medicaid benefits, then there's a lot of planning you can do to protect it from those things. Now, one of the things that people will often ask about when it comes to these types of properties, or just really any real estate in general, is whether it's a good idea to, during lifetime, gift the property over to the children, just transfer it to their name. This comes with its own risks, and sometimes these risks are, and most of the time actually, they far exceed the risks of Medicaid availability. So when you transfer ownership to somebody else, when you just put it in their name, well, they own that property now. And that comes with some restrictions potentially for you. It also comes with some liability concerns. If they own that property, your kids, well, they could say you don't get to use it anymore. And maybe you really still want to use that up north family property and you want to have access to it still. Hopefully your kids are better than that, but it's a concern. Another liability concern that comes along with that, though, is anything that happens to the owner of a property, it technically happens to that property as well. So when we're often planning around these properties, we're looking at protecting these things from nursing home expenses. But if you transfer these properties over to your kids, they might not be worried about nursing home expenses, but if they just own it themselves and they get divorced or they get sued or file for bankruptcy, I mean, these are things that can now happen to that family property because it's in their name and it's an asset of theirs. So you might have protected it from your care, but opened it up to the liabilities of maybe one or more additional people, depending on the size of your family. Another thing to be aware of with these sorts of transfers is for Medicaid, there is a 5-year look back. So it's not like you can just transfer this over the day before you apply for Medicaid. You want to try to plan prospectively in general, but another generality is just putting it in the kid's name is not generally the best idea. It also comes with some tax considerations as well that you should be aware of before you gift property over. When you bought the property from, for your family, or you inherited it maybe from your parents, the cost basis you have in that property is the fair market value as of that date, right? What you paid for it, for example, or what the fair market value was when you inherited that property. So if you gift it over to your kids, you transfer that cost basis over to them. What that means is if they're going to sell it at some point, if they maybe don't want to hold on to it forever, there could be some significant capital gains issues because they had a much lower cost basis in it versus the sale price that they sold it for, as opposed to if they had inherited that property, that cost basis at the time of your death, or maybe your surviving spouse's death, would get adjusted up to fair market value, that cost basis. So if they sold it after that point, they would at least have reduced capital gains, maybe none, depending on when they decide to sell it, as opposed to if they inherited it or received it at a much lower cost basis through a gift. So I know with family legacy property, it's not often a concern to gift these things or to sell them and have a higher cost basis, but it's something to be aware of because there can be times where somebody or the family just gets together and says, we can't deal with this anymore. None of us really want to use it, or our kids maybe don't want to use it, and they do decide to sell it. And so if that happens, you want to at least set them up the best you can for tax situations like that. So another really common concern, though, when it comes to these family legacy properties is not so much maybe even long-term care, or maybe it's in addition to long-term care, is making sure that the family gets along well enough or has a structure in place to help them get along to avoid certain disputes kind of tearing the family apart, and potentially driving a wedge between them, so that none of them want to work with each other anymore and they don't want to own this property together. The goal with these family properties is to have them stay in the family and to have the family enjoy it together. But with owning property comes a lot of decisions or potential disagreements that, if there's not a good structure in place to deal with those things, could ultimately force a sale between the family members anyway. Worst case scenario, they could have a forced judicial sale simply because nobody agrees on anything and it's just unworkable. So there's a lot of things that these properties can create in terms of disputes. So for one thing, how is the property used? Who gets to use it and when? If it's a property that's commonly used in the summer or for holidays during the summer, is everybody going to get to use it whenever they want? Is there going to be sort of a structured schedule? Does it have to be used by the family specifically, or what happens if somebody allows somebody outside of the family to use that property? Is that allowed? I mean, these are the sorts of things that maybe you think aren't going to be issues, but the more people you start to get involved, the more that this can become an issue down the road. There's also oftentimes disputes over payment of expenses. And so those could be things like property taxes, utility bills, maintenance costs, improvements to the property. It all depends on what kind of property it is, but there's always some expenses for that property. And if everybody's just equal owners in it and there's no sort of structure in place, in theory, everybody is responsible equally for those expenses. However, there's not a structure in place to deal with what happens if somebody is refusing to pay their share of those expenses. So you want to plan around that and say, either we're going to fund so much money into this thing that nobody's ever going to have to worry about expenses, which is quite frankly unrealistic for most people. Or you want to have some sort of agreement in place ahead of time where it spells out what happens if one owner of the property does not share in those expenses equally. There's also often a huge concern with, well, what happens if down the road somebody doesn't want to be a member anymore or an owner of that property? Do they, get bought out at fair market value? Is there a discounted rate that they have to offer it to the other owners at? Or, what do you want to see that look like? And again, if you just have them own this property outright with no sort of structure in place, they sometimes are caught in a bit of a catch-22 where they want to sell it for fair market value, but nobody wants to buy it for that. And they can't sell it outside of the other owners because it's hard to sell to a third party when they're going to own a portion of a whole with a bunch of people they don't know. So it can really force the family to stay together, but not in a way you want to force them to stay together, in a way that's going to breed discontent or disagreements amongst people. So you want to provide a structure for how they settle on a price. Of course, there's many options when it comes to that. You could set the price, although I generally wouldn't recommend setting a just flat dollar amount for a buyout price, because maybe that's perfectly reasonable today, but is horribly out of line with what the fair market value would be in 20 or 30 years. $100,000 today is worth a lot more than $100,000 in 30 years, for example. So you want to be careful about setting just a flat dollar amount for buyout prices. But when it comes to that buyout price, are you saying, look, they can get it appraised, and if there's disagreements over that appraisal, they can get a second appraisal, but it's going to be fair market value. That's what it's going to be. Or do you want to say, well, they should get some amount of a discount, the people buying it, because it's family property and we want to incentivize them to stay family owners only. You could put some sort of agreement in place that says, well, it's discounted at 20, 30, 40%. Maybe that's a little too significant, but you can come up with a discounted rate to sort of incentivize that internal family transfer as opposed to what they could get selling to a third party. And you can put rules in place that say they have to offer it to those other family members first, that they can't just go to a third party and get more. That would be essential to make that discounted rate work. So buyout prices are a very common concern. I'll sometimes also see people say, well, if they want out, they get nothing. And that's probably not ideal either, because although that seems like, well, we shouldn't incentivize a sale, so we're going to say they get nothing for it, you run into the issue of, well, if I'm going to get nothing, even if I'm unhappy with the current arrangement and I'm causing problems or somebody else is causing problems, if I get nothing for it, I might as well just hold on to the property anyway. And so you kind of force them together again in a way you don't want. And that could also always be avoided if there's some sort of judicial sale, for example. So you might be thinking, well, how do I actually create this structure? How do I do any of the things that Justin just mentioned about putting these rules in place and agreement terms for buyout prices and all of that? Well, oftentimes what we're looking at doing with this type of property, if we want to put these structures in place, is looking at using some sort of business entity to own that property then going forward, whether that's just for you or is something that the kids set up later on. Obviously, if you set up this business entity, you have a lot more control over what those rules for the kids end up being than if you wait for them to agree on it. So it's often ideal for you to set up your own entity for them to inherit this property with. Oftentimes, and probably most frequently, we're using what's called an LLC to own that property. LLC is a limited liability company, not corporation necessarily, like a lot of people think. And an LLC, in essence, is a business entity, but it doesn't have to be used purely for business purposes. Like, you don't have to actually be renting out the property or selling goods or services through it. That's not necessarily what has to happen with that property, although they in theory could start doing that if they wanted to. But what's very important with an LLC is, rather than having a bunch of different owners of the property itself, that LLC is the owner of the property. It's one owner. Now, the kids that you might involve in this or the family members you might involve in this LLC are owners of that LLC. They own shares or interests or however it's defined in that agreement. They are part of that LLC. Now, you don't just want to create an LLC and transfer the home over to it or the cabin to it and say, we're good, we have an LLC. It's also very important to have a written operating agreement for that LLC, which is essentially the rule book for the business that you've created and you set those rules in place. That operating agreement can spell out how the company is managed, who makes the like day-to-day decisions. Is it all of the members or is it a managing member or manager of that LLC, somebody who is elected, so to speak, to make those day-to-day decisions? What rules are in place for who can be a member, for example, not just who initially is a member, but who can members actually transfer their shares to? Is it limited to your descendants? Can they leave it to a spouse? Do you want to prevent that from happening? That's where you spell all of that out of who can actually own this LLC. Oftentimes we will restrict it to the descendants of our clients so that if the goal is for it to stay in the family, they can keep it that way. Now, that can be, they can avoid that restriction, assuming all of the other members agree to that person's desired transfer. So they can't always get around it, but it certainly makes it much harder because they can't just do it unilaterally. It has to be approved by everybody else. This LLC operating agreement often spells out, well, okay, if somebody's not paying their fair share of expenses and the other members are taking on those expenses, eventually that person who's not paying their fair share can eventually lose their ownership in the company simply because the amount of expenses they have not paid or are outstanding eats up the equity they have in that business and gets redistributed to the other members who have been covering those expenses. So it can provide a way to really say, look, if you can't cover expenses, that's fine. But eventually you either have to sell your interest or it's going to be eaten up anyway because you simply haven't been covering your share. So in some ways that actually incentivizes those people to sell if they want to, because they're going to get more money that way than if they just don't get anything because they haven't been paying property taxes, for example. But the operating agreement itself, or sometimes in conjunction with another agreement, can also spell out how buyouts would work, the prices, and what triggers those buyouts. You know, is it something that happens when somebody dies that the other members have the option to buy out that share? Is it the deceased person's estate that has the right to sell that share? And are there certain other triggering provisions for that buyout? Things like if somebody would go into a nursing home and didn't have prior planning in place to avoid that being an available asset where that impacts the rest of the family, does that give the family members the option to say, well, John went into a nursing home and we don't want this to be subject to a Medicaid estate recovery lien, so we're going to buy them out and just not have to worry about it anymore. That doesn't protect the value for that person who's in the nursing home, but it does protect the family property from what's happening to that person in the nursing home. And so it can be a way to protect that property specifically. So buyout provisions are great, both in an operating agreement at times and sometimes in a separate buy-sell agreement, it's often called. Providing rights of first refusal for the other members can happen in an LLC operating agreement. It's a great tool to provide that structure for the family of how this is going to work. Another huge benefit of an LLC, quite frankly, is that if something happens on that property, so if you have an LLC for this property or the kids do eventually on their side as well, what it does is it protects those members from what happens on the property or with the property. So especially the more family members you start to get involved, or if you do allow outside usage for non-family members, as is often the case, somebody says, well, my best friend wants to use the cabin this weekend, and everybody says, that's fine. You know, if somebody gets hurt or there's something that causes a liability that could lead to a lawsuit or creditor concerns of any kind, it can protect the members, their assets from the liability of that business or of that LLC entity. So this is great for anybody who has up north property, quite frankly, whether or not they expect to have like a long-term family legacy with it. because you're not always on this property and you might want to protect yourself from what happens when you're not there. Now, this is another reason, though, this liability protection, that having a written operating agreement is so important. You don't actually need to have a written operating agreement to have an LLC. The law in Wisconsin says if you filed to create the LLC, you technically have one. And if you haven't signed a written operating agreement, the state has defined sort of default rules for you through the statutes. Or if you've just kind of been operating it a certain way and everybody's been in agreement, and if that somehow differs from the state defaults, you have what's called an implied operating agreement. So this is something that can mean you have these rules for this business that you might not be aware of. You might be violating at some point because you don't know that you have these rules. And in theory, if you violate the terms of your operating agreement, especially routinely, and somebody sues the LLC, they can try to see through to the individual members and go after them for that liability. That's what we call piercing the veil. And the whole idea of that is you have been disregarding all formalities of this LLC. You've been treating it no differently than yourself, as if you guys own it, or you've just been completely disregarding the rules. So we're not going to afford you that liability separation anymore because you have done nothing to earn it, right? So having a written operating agreement, why that can be so essential is you decide what those rules are. You have a written agreement you can refer back to if there's ever concerns of, are we allowed to do it this way? Or is there another way we agreed on doing it initially? Should we keep following it that way or amend it? It gives you something to look back on and say, okay, this is what we're supposed to do. This is what we're going to do. We're going to follow that. And as long as you follow the formalities of that operating agreement, it's very, very difficult for anybody to ever see through to the original members unless somebody is just so, egregiously fraudulent or acting in bad faith that they, don't have that protection anymore. So having a written operating agreement is important, not just because of that liability protection that it can help you maintain, but also because that's where you're going to spell out all of these rules of how you want things managed. If you don't have one of those written operating agreements, you could in theory have an implied operating agreement just because you've been acting that way. But that's a relatively new concept under Wisconsin law within the last couple of years. The problem with those implied operating agreements is, I don't know about you, but I don't remember everything I've ever said to somebody or like what we agreed on 5 years ago. Or, if there's a deviation in theory from standard practices because nobody really knew what those were. I mean, that can be a huge problem to try to rely on something that's not in writing. There's also certain types of management styles that you can actually only afford through a written operating agreement in Wisconsin. So if rather than having a member managed LLC where everybody has equal voting rights, you say, we want one person at a time to be making major decisions. That's what's called a manager managed LLC, and that has to be done in a written operating agreement now. That's a new change as well within the last couple of years. So LLCs provide great planning for that management structure of the property, puts the rules in place that people are going to have to follow. They can agree to change those rules at some point, but you set the threshold of what those voting percentages need to be for those changes. So it's much harder for them to change things if you've already created those rules, which is why earlier I said it's better for you to create that than to say to the kids, we'd like you to set up an LLC later because now they have to agree on all those rules, and that can be really difficult. Easier for one or two people to agree than 5, right? So it's great for that management structure. It's great for the liability separation from the owners and the property. But LLCs in of themselves do not protect the property from liability. So what that means is still very important to have insurance and have that LLC insured. It's also very important to make sure that if long-term care expenses are a concern, that you're aware that just because it's in an LLC does not automatically protect it from Medicaid availability. That's a very common misconception that, well, we have it in an LLC and there's a business exemption for assets, and if they're a business, they're not available for Medicaid. There is a business exemption for Medicaid, but it has to be an active trade or business that is actively operating. And just having an LLC is not an active business. Even if you're renting out the property, that does not rise to the level of it being an active business that is unavailable for Medicaid. So a lot of people think, well, I have an LLC, so I'm protected. No, it's not going to protect you by itself. If it is an active business, separate from a family legacy property that you're running through an LLC, that could be different. The problem with even that exception, though, is that eventually it's not going to protect you, because Medicaid can recover against your estate when you pass away unless you have things owned a certain way. And they can recover for what they've paid out in benefits against the interest in an LLC. So just because they can't do anything with it while you're alive doesn't protect it forever. So even that is not something you want to overly rely on. Now, what does protect LLC interests or property in general is when it is owned by an irrevocable trust, for example. And that irrevocable trust is a much better tool to protect assets from long-term care than just putting things into the kid's name. And just going along the reasons I mentioned why putting it into the kid's name is not ideal. If you have property owned by an irrevocable trust that you've established, you can have a written occupancy agreement signed saying we have the right to use the property, general usage as we see fit, as long as we keep paying the property taxes and utility bills on it, and upkeep and maintenance and whatever expenses come up. So that both protects you from not being able to use your own property, but it also protects you from making additional divestments every time you're paying those property taxes. Probably the most common mistake people make after they've put the home in the kid's name is they keep paying their property taxes, but Medicaid is going to look back on that and say, why are you doing that? You don't own the property anymore. So not having an agreement in place creates a problem there. But an irrevocable trust also does a few other things that protect you. It makes sure that while you can't be your own trustee for Medicaid purposes, maybe you do still put the kids in charge of that property. However, you're putting them in the role of trustee, not of an owner. And if they're the trustee of that property, they don't have, their personal liabilities does not impact the trust in any way. So I could be somebody's trustee, I could file for bankruptcy, and that's not going to impact their trust at all because I don't own it. I'm managing the trust. I make some decisions, but that doesn't mean my liabilities affect the trust. So it protects you from that, issue of, well, if the kids get sued or divorced or anything like that, that's going to impact my home now or my property, my up north property. The other huge benefit of a trust like this is it still gets a step up in basis when you pass away. So you're still wiping out those capital gains concerns, or at least reducing them significantly depending on when they sell the property. It can also be set up to protect your children the way they inherit from their future creditors, future divorce, future Medicaid availability if they need to plan for their long-term care. So your trust can set up that protection for them. And if you have both an LLC and an irrevocable trust for properties like this, you have both that management structure for that LLC in place. You also have other protections from long-term care for you, for the kids, from their liabilities down the road. It can be a great combination of two planning tools to protect both from long-term care availability and just keeping family harmony going at some point. So with that irrevocable trust, you can also place additional restrictions in terms of where they can leave their shares of the LLC, even on top of what the LLC allows. So it's a great combination of tools there. So I'm out of time here, I'm seeing. I don't see any questions. This can be an incredibly, to me, interesting topic, but also very complex. And there's a lot of potential moving parts of how you would want this to work or what your concerns are. It can be more complex or more simplified depending on what agreements need to be made in advance. But if you are concerned about protecting your family property, whether it's hunting land, cabin, lake home, what have you, you can create an LLC to provide that structure for the next generation. And you can also look at if long-term care concerns are an issue for you right now or in the near future, look at having that LLC owned by an irrevocable trust to protect it from your care needs. Now you do want to try to do that planning as prospectively as you can, because obviously the 5-year look back is still a concern when you're putting things in an irrevocable trust. But just as a reminder, before I sign off today, keep an eye out for that email with that feedback form, which can let you know or let us know that you want to reach out, us to reach out to you, excuse me, to set up that initial consultation. Again, those are complimentary, so if you want to come in and talk to us, please feel free to fill that out. And then keep an eye out as well for that family legacy property handout that we'll provide as well. This is a good timely topic for Memorial Day coming up here this weekend. So maybe use this weekend as an opportunity to talk to your loved ones and see who's interested in these properties, what they see as the future of that property, and whether they like the concept of having sort of a rule book in place for the property. And then just next week, we will be talking more about that Medicaid spend down and availability. So some of what I talked about today will be talked about in more depth next week as well. But otherwise, I hope everybody has a happy Memorial Day weekend, and hopefully it's good weather for everybody. But have a good rest of your day, and we'll